Hello and welcome to the channel. Today we're going to discuss the case of B, a child, Care Proceedings 2018 EWCA CIV 20. The key issues discussed in this case are the role of prospective adopters in care and placement proceedings, as well as placement with siblings in adoptive placement versus placement with a family member. There were three related cases which were considered in this judgment, and those are Re T, a child, early permanency placement, Re G, minors, interim care order 1993, and Re W, a child, 2016. So, to the relevant facts of the case. The case is about a little girl called B, and she was born in the spring of 2016. B has an elder full brother called H, who was born in 2015. He was adopted in 2016. The essential issue before Judge George, who was the presiding judge in the first instance, was whether B should be placed with H's adoptive parents or with her father's cousin I and her partner R. Judge George gave judgment and made her order on 21st of August 2017. She made care and placement orders with a view to B's adoption by H's adoptive parents. That decision was challenged by the family, and an appeal was lodged to the Court of Appeal. That came before MonBP President, who gave the leading judgment in the Court of Appeal. MonBP considered that this case was significant because it explored the ramifications of the decision of this court in Re T, as well as the decision in Re G and Re A. In the latter case, MonBP pointed out the key decision of Wilson L.J., who stated the following: "As a judge of the family justice system for almost 15 years, I have never encountered a case in which an aspiring adopter participated in hearing of proceedings relating to whether a child should be placed for adoption or should be freed for adoption under the old law set out in Section 18 of the Adoption Act 1976. For the law provides a forum in which issues as to the identity of the optimum adopter can later be ventilated. In my view, therefore, the requirement for close scrutiny of the care plan should in principle not extend to an address of any issue as to the identity of the optimum adopter or adopters for the child." MonBP himself echoed the same point in Re T when he said the following: "The care judge is concerned at most with consideration of adoption in principle, not with evaluating the merits of a particular proposed adopter. There is no need for the prospective adopters to be joined, for it is the children's guardian who has the task, indeed is under the duty, of subjecting the local authority's care plan to rigorous scrutiny and, where appropriate, criticism." Once he had established that care and placement proceedings are not the appropriate forum for determining the identity of the optimum adopter, MonBP went on to consider and approve the judge's analysis in Re T, that is, Judge George's analysis in Re T, and in particular the circumstances in which a court can give consideration to the benefits that an identified prospective adoptive placement can offer as part of a holistic analysis of the options available to the child under the Adoption and Children Act 2002. Judge George's analysis, as approved by MonBP, was as follows. Re T was a case where the potential adopters had also been the child's foster carers for a period of time, and they sought to be made parties to proceedings. The court found that it was not necessary for the prospective adopters to be joined. They had already been positively assessed and cautioned against, in a case such as that one, allowing the process to become a dispute between prospective adopters and the birth family, lest the court be diverted into an illegitimate inquiry as to which placement will be better for the child, because that is not the question before the court. This case can be distinguished from that one of B, because B has no existing relationship with the proposed adopters as existed between the child and prospective adopters in RET. I have to determine this case in the knowledge that the prospective adopters for B care for her full sibling brother. To the extent that that fact is known, a degree of comparison between the options before the court is unavoidable in seeking to establish what B's welfare needs are and how they can best be met. That inevitably happens when the court weighs up the pros and cons of each option. However, as I hope these judgments will show, it is the principle of adoption that the court is considering in the particular facts of this case, not choosing the better of two alternative placements. Monbp went on to refer to REW, in which McFarlane LJ ruled that the existence of a viable home with the grandparents should make that option a runner, but should not automatically make it a winner, in the absence of full consideration of any other factor that is relevant to the child's welfare. This therefore makes it plain that there is no automatic presumption in favour of a family placement, but should be treated as one of the viable options to be considered along with all other relevant factors. Finally, Monbp went on to dismiss the appeal and made the following observations which set out the key essence of this judgment. How else was the judge to proceed? She was confronted with the fact, the reality, that B's only full sibling, H, a sibling close to her in age, had been adopted, and that H's adoptive parents were willing to adopt B. That was not something the judge could ignore, as it were put it out of her mind if she were to comply with her statutory duty under Section 1.4 and in particular Section 1.4f of the 2002 Act. And in having regard to that objective, factual reality, the judge was doing nothing inconsistent with the learning in RET and the earlier authorities to which I have referred. As Mr. Tyler and Mr. James would pointedly observe, there is nothing in RET to say that the court can ignore a crucial factor which is necessarily concomitant with a particular placement. The presence of H in B's life must fall in the credit side of the balance sheet in relation to placement with H's adopters, just as the loss of H must fall in the debit side in relation to the kinship placement. To ignore this would, they say, be a nonsense, and I agree. So what are the key takeaways from this case? The key takeaways from this case are twofold. Firstly, there is no automatic presumption in favour of family placements, but should be treated as one of the viable options to be considered along with all other relevant factors. And secondly, the care judge is concerned at most with consideration of adoption in principle and not with evaluating the merits of a particular proposed adopter. There is no need for the prospective adopters to be joined, for it is the children's guardian who has the task, indeed is under the duty of subjecting the local authority's care plan to rigorous scrutiny and where appropriate criticism. Thank you for listening to this video. You have been listening to the Child Protection Lawyer. Please subscribe.